Welcome back. In this subunit, we're going to discuss the UCC approach to damages. All right, let's talk about how the UCC approaches damages for breach of contract. We're going to talk about the UCC approach to general damages, right? Buyer's damages if seller is in breach of the contract, and seller's damages if buyer is in breach of the contract. We're going to talk about incidental damages. We'll talk about consequential damages. Now, here's a quick preview. Only the buyer is entitled to consequential damages under the UCC. If the seller is in breach, the buyer is entitled to consequential damages, subject to limitations, of course. And if the buyer breaches, seller is not entitled to consequential damages. And we'll also talk about the UCC's approach to liquidated damages. Okay, let's talk about the UCC approach to general damages, the basic concept. Remember, we talked about general damages, and we said to put the aggrieved party in as good a position she would have been had the contract been performed, we have to give her the benefit of the bargain. She would have been better off if the other party had performed her obligations under the contract, and so we have to kind of replicate that by giving the aggrieved party a sum of money that will put her in as good a position she would have been had the contract been performed. The UCC measures general damages generally by looking at substitute performance, the cost of substitute performance. Well, what does that mean specifically? Well, if seller breaches and we are going to award buyer general damages, how will we measure those damages? Well, based on the cost of substitute performance. So if buyer goes out and acquires those goods from another source, we call that cover. Buyer will be entitled to cover damages, the additional cost of getting those goods from another source. Or if buyer doesn't actually go out and cover and get those goods, we will use virtual cover, which we call market damages. So we look at the market price. What would buyer pay to get those goods from another source? So for buyer, to measure buyer's damages when seller is in breach of the contract, we look at cover damages, the cost of getting those goods from another source, or we look at market damages, the virtual cost of getting those goods from another source. Similarly, if buyer breaches the contract, seller has resale damages. And what are resale damages? Well, resale damages is where the buyer goes out and sells those goods to another buyer, right? And we look at the cost of that. Did seller sell it to another buyer at a lower cost? If so, seller is entitled to damages from the breaching buyer. Then we could also look at market damages for seller. This is where seller doesn't actually go out and sell it to another buyer. This is where we look at a virtual resale to another buyer. Okay, buyer's damages. What if seller fails to deliver the goods? Seller doesn't deliver at all. Or what if seller delivers and buyer rejects the goods, rightfully rejects the goods? Or what if seller delivers and buyer rightfully revokes her acceptance? What damages is buyer entitled to? Well, buyer is entitled to general damages. And how do we measure buyer's general damages? We measure buyer's damages by either cover damages or market damages, right? Cover damages is the cost of getting substitute goods. So if buyer enters into a contract to buy goods from seller for $10,000, seller either doesn't deliver or delivers non-conforming goods, which buyer rightfully rejects, or seller delivers non-conforming goods, which buyer rightfully revokes her acceptance. And then buyer has to go out and buy the goods on the market. She can only get them for $12,000, she's entitled to cover damages of $2,000. The contract price was $10,000, the cover price was $12,000. Buyer's entitled to $2,000 in cover damages. Well, what if buyer doesn't actually go out and cover? Well, she still gets damages based on cover, but she doesn't actually go out and cover. So what we say is, if she had gone out and covered, if she had actually gone out and bought those goods from another source, how much would it cost her? And then we look at the market price of the goods at the time of breach. So once again, same fact pattern. Seller either doesn't deliver or delivers non-conforming goods for which buyer revokes her acceptance or rejects. Buyer then doesn't go out and cover, but if she had gone out and cover, it would have cost her $12,000 to cover. Those are market damages, and buyer would be entitled to $2,000. Generally, market damages and cover damages are going to be the same. If you go out and cover, you're going to go out and buy at market price. If you don't go out and cover, then we just look at the market price. All right, here's a basic fact pattern that has several different scenarios through which we can explore what buyer's damages will be when seller is in breach of the contract under the UCC. So buyer and seller enter into a contract for the sale of 100 widgets for $10,000. So contract price is $10,000. Seller breaches. How does seller breach? Well, seller never delivers and buyer covers. Buyer goes out and finds substitute goods for $11,500. So that also means that the market price is $11,500. Think of that as virtual cover. The market price is $11,500. What if buyer rightfully rejects delivery, right? Seller delivers non-conforming goods. Buyer rightfully rejects delivery. Then buyer goes out and finds substitute performance, goes out and covers for $11,500, or the market price is $11,500. Buyer rightfully revokes her acceptance. Buyer goes out and covers and finds substitute goods for $11,500, or the market price is $11,500. So in each of these situations, seller has breached, buyer covers for more than the contract price. The contract price was $10,000, buyer covers for $11,500. I'm assuming this was all reasonable cover, right? Buyer covered in reasonably commercial sales. So what will buyer's damages be? Well, it's not that hard to calculate, right? Seller is going to be responsible for $1,500 in damages, right? And how does this fit into what we've learned? Well, $1,500 will put the aggrieved buyer in as good a position she would have been had the contract been performed. If seller had performed the contract, buyer would have had 100 widgets for $10,000. Because seller breached, buyer had to get widgets, those 100 widgets, and had to spend $11,500. How do we make sure that buyer has received its widgets for $10,000? We have to force seller to compensate buyer $1,500. And so seller will be required to pay $1,500 in damages to buyer for seller's breach. What if buyer had already paid seller a $5,000 deposit? Well, naturally, seller has to pay that back. And so, if that were the case, then seller would have to pay buyer $6,500. What is that? That's the $5,000 deposit plus the $1,500 in damages. What if buyer lost a customer because of seller's breach? Buyer says, listen, I was going to resell those goods to another customer, and because you were late, even though I was able to cover, I lost a customer. Well, that's an issue of consequential damages. Right now, we're talking about buyer's general damages. All right, let's continue our discussion of buyer's damages when seller is in breach. We've talked about 3 different situations, right, where seller fails to deliver the goods or where seller delivers non-conforming goods and buyer rejects them, or the third situation where seller delivers non-conforming goods and buyer revokes her acceptance. What if, however, buyer delivers non-conforming goods and seller keeps those goods? How do we measure seller's injury? How do we measure the damages that, how do we measure buyer's injury? How do we measure the damages that seller must pay to buyer? Well, the UCC is not real detailed on this, but it gives the answer that we would expect, right? So if buyer accepts non-conforming goods and keeps them, we will determine damages in any manner that is reasonable. What is a reasonable manner? Well, if you send me non-conforming goods and I keep them, probably a reasonable manner of determining my injury, determining the damages that you have to pay me, is the difference between what was promised and what was delivered, or the cost of repairing the problem, right? So either the difference between what was promised and what was delivered, or remediation. Now, there's a really important point that you have to understand under the UCC, a very important provision. If buyer accepts non-conforming goods and then buyer wants to sue seller for breach, buyer first has to give notice to seller of the breach. If buyer does not give notice to seller and immediately goes to court to sue the seller, the court will dismiss the lawsuit. All right. So what if seller delivers goods to buyer that do not conform to seller's warranty of the goods? Well, the answer is simple. Buyer is entitled to recover the difference of the goods as warranted versus the goods as delivered. We have the same limitation though. If buyer accepts those goods, those non-conforming goods, before buyer can sue seller, buyer has to send notice to seller of the breach of contract. If buyer does not send that notice to seller and immediately goes to court to sue seller for the breach of warranty, the court will dismiss the lawsuit. Let's talk about seller's damages under the UCC when the buyer is in breach. So we're generally first going to talk about three situations where the buyer has refused to pay for goods before delivery. Sometimes the buyer and seller will enter into a contract where buyer is supposed to pay before seller delivers. If buyer refuses to pay, then buyer is in breach. Another situation is where buyer wrongfully rejects the goods, and the final situation is where buyer wrongfully revokes her acceptance. In these situations where buyer is in breach, what is the measure of seller's damages? Well, seller's resale damages will be the measure of her general damages, right? The difference between the contract price and the resale price will be the measure of her damages, or market damages. The difference between market price and the contract price will be the measure of seller's damages when buyer is in breach. Let's look at an example. Let's further explore seller's damages under the UCC when buyer breaches the contract. So here's our little fact pattern. Buyer and seller enter into a contract for the sale of 100 widgets for $10,000. Now, buyer wrongfully rejects the goods, or buyer refuses to pay on delivery or before delivery as the parties had agreed, and so seller doesn't deliver the goods, or buyer wrongfully revokes her acceptance. The market price for 100 widgets had dropped to $8,500 at the time and place for delivery. So that's our market price. If seller at this time had gone out and found a substitute buyer, we can just assume that seller would have sold the widgets to the substitute buyer for the $8,500. So those are the resale damages and the market damages, right? the $10,000 contract price minus the $8,500 resale damages or the $8,500 contract damages. So seller's damages in this case under the UCC, any one of these cases, would be $1,500. How does that fit into what we've learned? Well, if buyer had not breached this contract and gone through with the transaction, seller would have received $10,000 for 100 widgets. Because buyer breached the contract, seller was only able to receive $8,500 for these widgets in either an actual resale or a virtual resale, the market price. Therefore, to put seller in as good a position she would have been had the buyer performed this contract, we have to give seller $1,500. What if buyer had already paid a $5,000 deposit? Well, buyer's in breach, but we're not going to penalize buyer, and so we're going to require seller to give that $5,000 deposit back to buyer. But buyer has to pay $1,500 to seller in damages, and so it winds up being a net benefit of $3,500, of $1,500 for seller. Seller has to return $5,000. Buyer has to pay seller $1,500, which means seller has to return $3,500 to buyer. What if seller had to warehouse the widgets for 2 weeks at a cost of $600? Yes, that's an extra $600. Buyer should have to pay that extra $600, but those are incidental damages, not general damages. And right now we're talking about general damages. Let's talk about seller's damages under the UCC when buyer is in breach under 3 different circumstances. First, what if seller is unable to resell the goods to another buyer? There is no market for the goods, and seller is unable to find another buyer for the goods. What are seller's damages? Well, seller can actually recover the contract price from the buyer. What if buyer accepts the goods but refuses to pay for them? Once again, seller can recover the contract price from the buyer. Finally, what if seller is a manufacturer and under the contract with buyer, seller has already begun to manufacture the goods? Buyer repudiates the contract. Should seller stop manufacturing, sell what she has already completed to a third party and use the raw materials and sell them for scrap? Or should seller continue to manufacture the goods, finish all of them, and then try and resell them to another buyer? Well, the UCC says that the manufacturer seller should exercise reasonable judgment. In other words, as long as the seller is thinking about whether she should finish or whether she should stop, as long as she exercises reasonable commercial judgment, we're not going to second guess her decision, right? If she says, you know what, I think that if I continue to manufacture and I complete these goods, they will be easier to resell than if I stopped and try and sold them for scrap or sold whatever I've completed and the rest for scrap. Remember, the whole idea is that you have to try and mitigate your injury, which mitigates the damages that the other party has to pay. As long as you're making a reasonable commercial decision about that, the court is not going to second guess you if you get it wrong. All right, let's continue our discussion of seller's damages under the UCC by talking about a special situation, the lost volume seller. Now, if you remember when we first started talking about general damages and measuring the benefit of the bargain, we said for a seller or a service provider, we will measure the benefit of the bargain as the profit that that seller or service provider would have made under the contract. Up till now, when we've been talking about the UCC measure of seller's general damages when buyer's in breach? We've said it's either resale damages or market damages. We haven't mentioned seller's profit. 2-708 sub 2 seller says seller can get the profit she would have made under the contract as the measure of her general damages. But the question is when? And the answer is when seller is a lost volume seller. Here's a little example to help you understand what a lost volume seller is. So I'm a car dealer and I enter into a contract to sell a car, a new car, to a buyer for $20,000. My profit for this will be $2,000. In other words, it's going to cost me $18,000 to get the car from the manufacturer. Then I'm going to sell it to the buyer for $20,000. My profit is $2,000. Buyer repudiates the contract, and I sell that car to another buyer. For how much? For $20,000. Well, if I'm using resale damages as the measure of my injury, as the measure of the damage that I'm entitled to, I'm entitled to 0. Why? Because the contract price was $20,000. The buyer breached. I resold that car to another buyer for $20,000, which means I have 0 in resale damages. But my argument is that I could have made both sales. I could have made a $2,000 profit under the original contract, and I could have made a $2,000 profit with this other party. I could have gotten another car from the manufacturer and sold it to that second buyer. So I'm arguing that resale damages should not be the measure of my damages. I am arguing that the resale of this car to that buyer was not trying to mitigate the original breaching buyer's damages. I'm arguing it's not a resale. I'm arguing it's just a separate sale because I could have made both sales. All right, so the UCC under the situation of the lost volume seller will give that lost volume seller the profit. The buyer will have to pay the profit. So how do we measure profit in this situation? Well, in the previous example, I basically told you how to measure profit, but if you understand accounting, what you're looking at is gross profit. So the contract price was $20,000. My cost of acquiring the goods is $18,000. And so the profit that I will get if buyer breaches is $2,000, right? Once again, if I'm the lost volume seller. Okay? Do not include other expenses that I might have into that calculation. For example, I might have salaries, I might have other overhead like rent and utilities. We do not calculate those into the expenses. What we're looking at is the contract price less the seller's cost of acquisition. And we said the cost of acquisition in this case was $18,000. The contract price was $20,000, which means seller's profit under this transaction would have been $2,000. If seller is a lost volume seller, then when seller sells that car to a third party, seller will not ask for resale damages. Seller will ask for lost profit, and seller will get it. Seller has to show, however, that it was a lost volume seller. Seller will have to show that it could have made both sales. All right, let's move on to incidental damages under the UCC. Both buyer and seller, both aggrieved buyer and aggrieved seller, are entitled to incidental damages under the UCC. Remember what incidental damages are? Incidental damages are the out-of-pocket costs that you incur dealing with the other party's breach. So if I'm a buyer and you send me non-conforming goods, I reject those goods. I have to put them aside and wait for you to come pick them up. I have to store them. The costs of storing those are incidental damages. If I am a seller and you are a buyer and you breach our contract, I now have these goods and I have to go out and find another buyer for those goods. Maybe I have to place an advertisement. The cost of that advertisement is an incidental damage. Are incidental damages. The cost of a broker helping me to find a suitable buyer, those are also incidental damages. let's talk about consequential damages under the UCC. All right, let's talk about consequential damages for buyer. Is buyer entitled to consequential damages under the UCC? Yes. Look at 2-715. 2-715 expressly says buyer is entitled to incidental and consequential damages. Is seller entitled to consequential damages under the UCC? And the answer is no. Seller is not entitled to consequential damages under the UCC. Why? Go look at 2-710. Under 2-710, it says seller is entitled to incidental damages. Makes no mention of consequential damages. But 2-710 does not expressly say seller is not entitled to consequential damages. So how do I come to the conclusion that seller is not entitled to consequential damages? Well, do you remember when we talked about maxims of construction? We use those maxims to construe contract terms. Well, you can also use those maxims to construe legislative or statutory terms. So one of our maxims was the expression of one is the exclusion of the other. So if we look at how the UCC is drafted, the UCC expressly says that buyer is entitled to incidental and consequential damages. The UCC also says that the seller is expressly entitled to incidental damages, making no mention of consequential damages. So if we apply the maxim, the expression of one is the exclusion of the other, we can only come to the conclusion that the UCC intended to exclude consequential damages for seller. All right, so we understand that buyer is intended to consequential damages if seller breaches the contract. What type of consequential damages are we looking for? Well, first, we're looking for the consequential damages of buyer's lost resales. Here's the idea. Imagine you enter into a contract with me. You're the seller, I'm the buyer. You're going to deliver televisions to me, right? And I am going to resell those televisions to my customers. So you deliver non-conforming goods to me, and I have to return them to you. I lose those sales to my customers. Those lost resales, the profits under those lost resales are consequential damages. What other damages I might suffer? Well, I might suffer lost attendant sales. So normally when I sell my televisions to my customers, I also sell other things to them. I might sell a TV stand. I might sell them a 1-year extra warranty. I might sell them whatever, other things that a person who buys televisions might also want to buy. Now, because you have delivered non-conforming goods to me and I have no goods to sell to my customers, I lose those attendant sales. What's the third category of consequential damages that a buyer might suffer when seller is in breach? Lost reputation or lost goodwill. So you sell non-conforming televisions to me. I sell those to my customers. My customers are angry because they got non-conforming televisions. I send them back to you. You try and make good, but in any case, I have lost the goodwill of my customers. My reputation has been harmed, and this is going to negatively affect my ability to make profits in the futures. Now, these are all consequential damages, but they are still subject to the limits on consequential damages. I have to be able to prove these with reasonable certainty, which may be difficult. Secondly, I have to show that these consequences were reasonably foreseeable to you at the time we entered into the contract. And they probably were, right? If you're a manufacturer of televisions and you know I'm a retailer of televisions and I'm going to sell these televisions to my customers, you know that if you send non-conforming televisions to me, that I'm going to lose the direct sales, I'm going to lose attendant sales, and I'm going to lose business in the future because of my damaged reputation. All right. Finally, let's talk about liquidated damages under the UCC. Remember what liquidated damages are? Liquidated damages are where we expressly put in the contract what damages each of us will pay if we are in breach. So if I breach the contract, I will pay you X dollars. If you breach the contract, you will pay me Y dollars. We put that in the contract. Now, remember what we said about liquidated damages, that they cannot be a penalty. If the court says that this was a penalty rather than liquidated damages, the court will say that the liquidated damages clause is not enforceable. So the whole idea of the law is to determine whether the liquidated damages clause is a liquidated damages clause or whether it's a penalty. And remember, the term liquidated damages it means liquidated, which means to make something uncertain certain. So that's kind of the whole test of whether the parties were trying to draft a penalty or whether they were trying to draft a liquidated damages clause. Were they trying to make these uncertain damages that we might suffer if you breach certain, or were they trying to create a penalty regime? This is the UCC. Now you can go read UCC 2-718, excuse me, sub 1 on your own, but the liquidated damages have to be reasonable in light of the anticipated or actual harm, right? There has to be a reasonable relationship between the harm that the aggrieved party actually suffers or the harm that we anticipated the aggrieved party would suffer. The difficulties of proof of loss and the inconvenience or non-feasibility of otherwise obtaining an adequate remedy. Remember, the whole idea is that, listen, if you breach the contract, I have these general damages and these consequential damages, and sometimes it's difficult for me to be able to prove my general damages, and it's going to be even more difficult for me to prove my consequential damages with reasonable certainty. So if you breach, I don't want to have to go to court and have this entire burden of proof. Let's just put in the contract how much you're going to pay me if you breach this contract, right? And as long as I'm not trying to penalize you for breaching, I'm just trying to use this liquidated damages clause to compensate me for the harm I expect to suffer, then it will be an enforceable liquidated damages clause.